Well, good morning, everyone. Thomas Montgomery. It's a beautiful Friday morning, January 13th, Friday the 13th, 2023. We get together with our distribution partners most mornings, weekday mornings this time, to discuss strategies, tips, techniques, share success stories, and support each of you. Today's topic is kind of a part two discussion, if you would, of our collateral support program. So what's not shown here on the screen, I'll just give you a little backdrop. And if you've missed that training, you can go back to our YouTube channel and see it. So it's not unusual that we'll have clients that have a capital raise goal, but they have a collateral shortfall. Collateral is what the client pledges to the lender in exchange for the loan. And if the loan isn't repaid as agreed, then the lender has the ability to come take that collateral, just like a house is the collateral on a mortgage. If you buy an automobile, you're pledging the car as collateral. If you don't pay the car note back, the auto financing, then they'll come take the car. When it comes to business financing, they typically are going to look at the assets of the business and say, what can the business owner pledge? When the business owner doesn't have enough to pledge, that's called a collateral shortfall. And what you and I can do is provide through the collateral support program assets, real assets, accounts receivable that go onto the balance sheet of the client. That resolves the collateral shortfall. With that being said, we also want to help. And so we're going to call those clients that buy collateral from us, the collateral support program, we're going to call those clients debt buyers, because that's technically what they've done. They bought a portfolio of debt from us, which is legal and ethical, to put onto their financials. What we want to do then is help them liquidate those receivables. And so I'm going to go through today and show you one of the instruments that we use to help our clients who are debt buyers liquidate the money that's owed to them. Hopefully that makes sense. So that's the backdrop. But I think it's important for you to see the process that we go through, one of the available processes we go through to help our clients who are debt buyers to liquidate. So there is an Adobe that we send out to the debt buyer. So we're not talking about this going to you, of course, and this doesn't go to the client. This is going to the debtors that are part of the portfolio that the client has purchased as part of the collateral support program, which again resolves the collateral shortfall. But we also want the debt buyer to recognize positive cash flow from that by collecting or liquidating that debt. Hopefully that makes sense. So no, we're not talking about suing you. This is not about suing you. This is about the litigation process to liquidate for the debt buyer. Hopefully that makes sense. So there is a cover sheet. So this is going to be sent to the client as an Adobe prompting them to sign it. So we're giving them notice. One of the things that we know the court system really likes is an attempt to settle the debt before the lawsuit is filed. So this is the last step before the lawsuit's filed. So the debtor, not you, not the client, the debtor would receive this via Adobe, and it gives them notice. You're about to be sued for breach of contract. We intend to file a suit against you and or your business for breach of contract, lack of payment. Now, the client should already know that they have obligations that they've not met. Before this occurs, they will almost always have received an invoice with an opportunity to pay or to resolve it, as well as additional notices. So I don't want you to think that this is like a strong arm approach to, we're going to sue you if you don't pay. This is the debtor has breached an agreement. They've been given ample opportunity to resolve that breach, and they've not. So this is the final step going into the case. And we clarify, we've not yet filed the suit. But if payment arrangements are not met, we're going to file the suit. And we have investors that will cover all those filing fees, because the filing fees can be expensive, but the return's well worth it. So a few relevant facts that we clarify. We're not a third-party debt collector. It's primary direct business debt. And that's important, right? Because there's different laws that apply to third-party debt collectors. We certainly are not third-party debt collectors. Therefore, those practices don't apply. Like once in a while, someone will come back and say, well, cease and desist. Well, no, we don't have to cease and desist. You owe us money, right? And if you owe us money, we have the right to collect. That's a point that some people confuse the difference between third-party debt collectors and primary. We again want to reiterate, hey, this isn't some strong-arm tactic to get money out of the debtor that's not owed. You've signed a contract, you've breached the contract, an invoice has been sent to you, you've not resolved it. Now, sometimes what will happen is people will want to come back and say, well, I don't owe you this because of this or that. Well, that's important. And so we let them know, hey, if you're disputing this, there has to be a written notice via first-class mail or fax. They can't just email back, oh, this is bullshit, I don't owe it. Well, that doesn't count. Or other false defenses that they need to validate why they don't owe that debt, because according to our records, they do owe that. And if they wanted to say, oh, well, you guys didn't do what you promised to do. Well, of course, all the contracts have arbitration provisions. And so if the debtor feels that they didn't get what was promised to them, then we should be over an arbitration using it's called ADR, Alternative Dispute Resolution, to resolve it. Obviously, they've not done that. Otherwise, we wouldn't be at this point right now. Clarifying, hey, just simply sending a call. We've got one guy, he's a character. When he receives this notice, he'll respond back, you've got the wrong person. Well, no, we don't have the wrong person, but in his mind, that's how he thinks it'll go away. And as Jared Kushner, son-in-law of former President Trump, has taught us with his famous expression, you will pay, this will not go away. So some people falsely think that they can just make a phone call or send an email and it'll go away. It's not going to go away. All right, so then we give them the option. If we don't want to sue people, and we want our debt buyers, who are our clients, those that are using the collateral support program, to get positive cash flow. So we do offer the debtor the ability, hey, make a payment today, which of course is going back to the debt buyer, the client, so they're generating positive cash flow. Hey, make a payment today and we'll stop the process and we'll resolve it. But it's not the option to just say, oh, I don't have the money, or other excuses. They need to pay, or they're going to be sued. And so that's where they can either make a payment to stop the process, to resolve it, or they will go to court. So all of the agreements state specifically that the venue, which means that there's both subject matter and personal jurisdiction, is in Wood County, Texas, which is where we're at. So that's, of course, convenient. We clarify that if the individual goes to court, they're still going to owe the amount of the breach, plus now they're going to have court costs and collection costs. We're going to be very aggressive, legally aggressive, in discovery. And so what we've found is that the discovery often makes or breaks the lawsuit. And so we're going to be able to start collecting information from the defendant to find out about their personal affairs, their business, their finances, subpoena email records, and so forth via court order. So again, for our debt buyers, this is an aggressive strategy to liquidate that debt, because it's not merely, oh, we're going to sue you if you don't pay. We're going to offer to settle. We will sue. and the lawsuit is expensive and time consuming for the debtor because of the discovery process. Now, it certainly could happen through the discovery process that we find out that the amount owed is actually larger than what was originally anticipated, and that can even sometimes require us to change the courts that we have, because there's different maximum amounts that can be sued. So let's say we have a white label partner, which isn't always the case. So these debtors could be defaulted white label partners, they could be defaulted access to capital clients, so forth. But let's say it's a defaulted white label partner. Well, when we do discovery with them, we may find that they've been competing with us using offering prohibitive services, and from that the amount that they owe is much greater. And so it may require us to move the case from small claims to county court, district court, or even federal court. And then we talk about the judgment afterwards. And liens are very effective, especially people that own businesses. Getting a lien against their business is a real strong collection tool. Homeowners getting a lien against their house. So then we get to the actual citation. And so this is the citation that will be filed with the court. It's not been filed yet. We're clarifying, hey, they're about to be sued. And again, if you came into this late, you may not understand where we're at, but just follow along the best you can. So again, we have to assess, are we going to file the suit in small claims court? Are we going to file it in county court? Are we going to file it in district court? Or are we going to file it in federal court? We're set up to do e-filing with all but small claims. Small claims is a bit more of a manual process, but we e-file with all the others. So then this again is a template that will go to the debtor, giving them notice. It'll be populated with their name. It'll be usually their name and their business name, because both of them are usually responsible under the contract. The address to be serviced at, a brief description of the complaint, the amount of damages. So again, if we're going through what's called JP court, we have a maximum of $20,000. If what is found to be owed is more than that, then we have to bump it up to county or district or federal court. But we'll put in an approximation of what we believe is owed here. Again, through discovery, we may find out that more is owed, and that may require a change of court. We also will sue them for the court costs, filing fees, expenses for service, and reasonable legal fees. They're going to be served by registered mail, so the county clerk will actually send that out. Now, some people try to be clever and then they don't sign for the registered mail when it comes. Then we file a motion for alternative service and then tape it on their front door or on their business's front door. We don't seek ongoing interest. We do not seek a jury at this time. We do allow service by email. We don't really prefer remote participation, so everything's going to be done in person at the courthouse here in Wood County, and so we find that generates the best results. That's a bit of a disadvantage for the person that's being sued, because instead of being able to do Zoom or phone calls, they'll have to come to court here in Wood County, and so that can be a bit of an inconvenience, but that is the way that it works. So we don't want to have hearings by phone call. We want to have them in person here, and we don't want to have Zoom. We want to have it in person here. So that means the defendant and or his or her attorney would have to show up in person. And then for small claim suits, we have to file the service member civil relief affidavit. So all this would be filled out. This is sent to the debtor to give them notice to try to resolve. So let's step back. So we have the collateral support program that is designed to assist our clients that have a collateral shortfall. What they're doing is literally buying a portfolio of debts. Here we're showing how we go about liquidating those debts. So the underlying debts could very well be breached agreements by white label partners and or by individual clients. We attempt to collect that money, which would provide positive cash flow to our client, the debt buyer, the individual that bought the collateral support program. If the underlying debtor doesn't pay, then we will typically litigate. And this is one process in which that we liquidate to be able to get money into the hands of the client, whereby their purchase of the collateral support program is positive ROI. And so we went through the cover letter, the offer to stop the suit in exchange for some partial payment, and then what the actual citation looks like. So the cause number, so this again is a template. When we send it to the debtor, there's fields that are filled in. Here's just the template, of course. So it wouldn't go to the debtor with blanks. It wouldn't be filed with the court with blanks. It would be filled in, of course. All right, so who has questions, comments, concerns on this process? We were asked by a number of you of how do we help our debt buyers liquidate the debts owed to them under the collateral support program, and that's why we're talking about it today. So questions, comments, concerns on that process? Alfred's asking if we're a member of the American Bar Association, and yes, we are. I have. It's not on here, but I have an ABA number that I could share with you if you need, Alfred. Yes, sir. Who else has questions regarding the relevance of this? Because what you and I do as technical advisors is we help clients access capital. To access capital, we know they need to be credible enough to get approved for funding. That's what you and I do. We help our clients become more credible. Credible, what does that mean? There's the 3 C's, right? Credit, capacity, collateral. If the client has a shortfall in any of those 3 C's, you and I can help them move from where they're at to where they need to be able to get approved legitimately and credibly. If the C that is an issue is a collateral shortfall, then we have the collateral support program where the client is buying a portfolio, heavily discounted, but buying a portfolio of debts. If you want to facilitate the process, then you can be the debt buyer. You buy the portfolio for wholesale, normally 5 cents on the dollar, 5,000 for every 100,000 of debts. Then you could turn around and sell that to your client at retail, which is normally 10 cents on the dollar. Thus, for each portfolio, you're flipping it, just like you could flip a rental property or flip a house, and you make $5,000. At the end of that transaction, the client now has $100,000 of assets, real assets, on their balance sheet in the form of non-performing debts. And what we're discussing today is how we then help the client liquidate those debts. And this is not the only way. We've talked about Petition 202 of the Texas Civil Procedure on a different training, but here is the typical process that we go through, and we're sending out a bunch of these today. Timothy asked, if a white label partner is not in compliance, do they receive this? Well, Timothy, great question. So if a white label partner breaches their agreement, we want to resolve that. We want to do what we promised to do, and we would ask the white label partner to do what they promised to do. But I guess ultimately the answer is yes. If someone breaches an agreement, we typically will package that defaulted agreement up into a portfolio and we sell it. Alfred's in the process of buying a big portfolio. A number of you have done that. We've sold portfolios to law firms even. So For defaulted deals, we package them up, we sell them, and so we would call that the debt buyer. And then if the debt buyer wants us to help them liquidate, which is a smart thing to do, then we litigate. And what we've shown today here is how we often, not only or always, but how we often litigate to liquidate for the debt buyer. Because again, if you follow the dollars, the debt buyer is typically paying 10 cents on the dollar. So buying $100,000 portfolio of real receivables. So let's just make it more specific for Timothy. So let's say we have 10 white label partners that have defaulted, which is shameful and shouldn't happen, but it could happen. So theoretically, we have 10 white label partners that have defaulted. They owe the license fee each owe $10,000. 10 times 10,000 is 100,000. So those can be packaged up. And let's say we sell those to Alfred. So Alfred buys it because he's like, yeah, if I can get $100,000 of receivables and only pay 10 cents on the dollar, that's great. So Alfred buys this portfolio of 10 defaulted white label partners, for example. So then we turn to Alfred and say, well, great, here they are. These debtors owe you, you're owed 100,000. Alfred's pleased as punch. We ask Alfred, do you want us to help you liquidate it? And Alfred could say, no, I'll take care of it. Or he could say, yes, you guys litigate. So then we would litigate it. The way that we would do that is we would invoice those 10 defaulted white label partners and say, hey, you've defaulted. Do you want to pay? You owe it. Everyone has an excuse, it seems. But if they want to resolve it, they resolve it. If they don't resolve it, then on Alfred's behalf, we could send this out to the 10 defaulted white label partners and then take them through court. It's great for Alfred because Alfred doesn't have to spend any time or energy on liquidating the debt. Alfred typically is going to get more than the face value, because in this example, each of the defaulted individuals owe the $10,000 on the license fee, plus late fees, which are $50 a day, plus court costs, plus filing fees. So now all of a sudden, instead of Alfred having owed, let's say 100,000, 10 times 10,000, it could be significantly more. So Alfred's asset has grown. Plus, we've helped Alfred liquidate the receivables without him having to get his hands dirty. We take care of it for him. There's some specific processes that have to be followed, and we've learned through the school of hard knocks of ways to do things and not do things to process this to make sure that it's in compliance, and this certainly is. All right, so today's goal was, in summary, to show you how one way that we go about helping clients who buy portfolios of debt, called the Collateral Support Program, that in addition to resolving their collateral shortfall for qualification for funding, how we go about helping them liquidate those receivables. That was the goal today. Hopefully that was helpful. We'll see you all back Monday morning. Have a great day, and let us know if there's anything that we can do to assist you. Thanks, everyone. Bye-bye.